Section 29. Document the file, protect the client, and protect your license. Course wrap-up. One file tells the story of the entire course. Michael places David's transaction file in the middle of the conference table. Ashley sits on one side, and Daniel sits on the other. For months, this property has taken them through almost every difficult situation an Arizona agent hopes not to encounter in a single transaction. Financial distress, a possible short sale, multiple liens, lender approvals, title problems, a notice of trustee's sale, postponements, contract extensions, buyer expenses, potential cure issues, and deadlines that seem to change every time someone answered the phone. Michael looks at both agents and asks one final question. If ADRE opened this file tomorrow, could someone understand exactly what happened? Ashley starts to answer, but Michael stops her. You don't get to explain it. You aren't in the room. They only have the file. That changes the question completely. Your file should be able to tell the story without you. Think about David's transaction from the beginning. If Ashley says she disclosed the foreclosure problem to the appropriate parties, where's the written documentation? If Daniel says Marcus and Elena were advised of a material risk affecting the seller's ability to perform, can the file demonstrate what was communicated? If David requested an extension, is the request documented? If the buyers agreed, is the actual modification there? If somebody delivered a cure notice, does the file show what was delivered and when? A transaction file should not require an archaeological excavation to determine what happened. AAC R4281101 establishes important duties Arizona licensees owe clients and other parties, including the fiduciary duty to protect and promote the client's interests, and written disclosure obligations concerning specified material or adverse information. Documentation helps demonstrate how those duties were performed. Remember where this course started. Go all the way back to Chapter 1. We started with something much simpler. What makes a contract? Offer and acceptance, mutual agreement, consideration, capacity, legality, written agreements when required by the statute of frauds. Then we learned that even a perfectly ordinary contract can become complicated when circumstances change. David's financial hardship did not erase contract law. His short sale did not erase contract law. His foreclosure did not erase contract law. Every time someone wanted to change the purchase price, extend closing, modify a term, issue a cure notice, or cancel the transaction, we came right back to the documents governing the parties. That is why experienced brokers constantly say, read the contract before you answer the question. Then the short sale changed everything. When David could no longer sell the property conventionally and satisfy the amounts required at closing, Ashley had to understand that a short sale added another decision maker to the process. The seller could accept Marcus and Elena's offer, but creditor approval could still be necessary for the transaction to close as contemplated. We learned about hardship documentation, lender packages, BPOs, valuations, subordinate liens, approval letters, closing conditions, and lender deadlines. Most importantly, we learned what Ashley couldn't promise. She couldn't guarantee lender approval. She couldn't guarantee the approval timeline. She couldn't interpret debt release language as David's attorney. She couldn't promise particular tax consequences. She couldn't hide transaction payments because they interfered with lender approval. Sometimes, the most professional sentence an agent can say is, "That's outside the scope of my real estate license. Let's get the appropriate professional involved." Then the foreclosure clock started. When the notice of trustee's sale appeared, the transaction changed again. Now Ashley had two clocks, the contract clock and the foreclosure clock. We learned that listing the property does not automatically stop a trustee's sale. Neither does accepting an offer, neither does opening escrow, neither does submitting a short sale package. We learned about the notice of trustee sale, postponement, reinstatement, trustee sales, judicial foreclosure, redemption distinctions, and Arizona's anti-deficiency protections. And again, the lesson wasn't that Ashley should become a foreclosure attorney. The lesson was that she needed enough knowledge to recognize the issue and enough judgment to know when to stop giving answers. One sentence can create a complaint. What's more dangerous? Telling David you don't know whether a legal protection applies, or confidently giving him the wrong answer? Ashley smiles. The wrong answer. Exactly. ARS Section 322153 gives ADRE significant disciplinary authority and identifies conduct that can create licensing problems, including misrepresentation, false promises, rule violations, negligence, and other improper conduct. An agent doesn't have to intentionally commit fraud to create a serious problem. Sometimes the problem begins with, "I'm sure it'll be fine. The lender will extend it. You'll definitely get your earnest money back. They can't pursue you for the difference. The foreclosure automatically stops because we're under contract." Those aren't harmless phrases when clients make financial decisions based on them. The transaction finally ends. A few days later, Ashley receives the call she has been hoping for. The remaining issues have been resolved, the required parties are prepared to perform, and the transaction reaches its proper conclusion. Marcus and Elena move forward. David closes this difficult chapter of his financial life. Daniel closes his buyer file. Ashley closes her listing file. Michael performs one final review. This time, the file tells the story. The real lesson was never just foreclosure. Michael asks Ashley what she will remember 6 months from now. She thinks for a moment. Probably that distressed transactions don't create different standards. They make the standards we already have more important. Michael nods. That's exactly right. Contracts matter more when the transaction becomes difficult. Deadlines matter more when foreclosure is approaching. Written disclosures matter more when performance is uncertain. Documentation matters more when people disagree about what happened. Broker supervision matters more when the agent is outside familiar territory. And knowing the limits of your license matters more when the client desperately wants an answer. That is the lesson I want you to take from foreclosures, short sales, and contracts. You don't need to know every answer. You need to recognize the question. You need to know where to look. You need to know when to call your broker. And you need to know when the client needs an attorney, CPA, lender, title professional, escrow officer, or another qualified professional. Because ultimately, good contract practice isn't simply about getting signatures. It's about protecting your client, protecting the transaction, protecting the public, and protecting your Arizona real estate license. Congratulations, you have completed foreclosures, short sales, and contracts. Online discussion. 1. Michael asks whether an ADRE investigator could understand David's transaction solely from Ashley's file. Why is that a useful risk management question? It forces the licensee to consider whether important events were properly documented rather than relying on memory. The file should demonstrate the contracts and modifications, disclosures, important communications, notices, approvals, deadlines, client instructions, and actions taken by the licensee. Good documentation creates a clear transaction history and helps demonstrate how the agent fulfilled professional obligations. 2. What is one of the most important lessons an agent should take from the short sale and foreclosure portions of this course? Answer. The agent needs enough knowledge to recognize important issues without exceeding the scope of the real estate license. Agents should understand the general processes and identify relevant deadlines, but individualized legal conclusions concerning deficiency liability, foreclosure defenses, debt releases, or similar issues should be referred to qualified professionals. 3. Why do difficult transactions make broker involvement especially important? Answer. Distressed transactions can combine contract law, lender requirements, foreclosure statutes, title problems, disclosure duties, and complicated deadlines. Broker involvement provides supervision and another level of risk review. Arizona law specifically recognizes broker supervision as an important licensing responsibility, and ARS Section 32-2153 identifies failure of reasonable broker supervision as potential grounds for discipline. 1. What is the best practice when an agent encounters a legal question concerning a seller's individual deficiency liability? Recognize the issue, involve the broker, and recommend qualified legal counsel. Guarantee that Arizona anti-deficiency protection applies. Ask another salesperson for a legal opinion. Ignore the issue unless foreclosure actually occurs. Correct answer: recognize the issue, involve the broker, and recommend qualified legal counsel. 2. Which practice provides the strongest protection when an important transaction issue develops? Promptly communicate it, appropriately document it, follow the contract and applicable law, and involve the broker when necessary. Rely on verbal conversations whenever possible. Wait until closing to disclose problems. Avoid documenting difficult conversations. Correct answer: promptly communicate it, appropriately document it, follow the contract and applicable law, and involve the broker when necessary. 3. What is the central lesson of this course? Understand the contract, manage deadlines, communicate and document material issues, and know when professional referral is required. Every short sale will eventually receive lender approval. Every foreclosure automatically cancels a purchase contract. Arizona agents should personally provide foreclosure, tax, and deficiency advice. Correct answer: understand the contract, manage deadlines, communicate and document material issues, and know when professional referral is required. True, false quiz. 1. Financial distress eliminates the party's contractual obligations. Answer: false. Written documentation can help demonstrate how an agent handled material developments in a transaction. Answer: true. 3. A licensee should guarantee outcomes controlled by lenders, trustees, courts, or other parties when the agent believes the transaction will probably work out. Answer: false. 4. Knowing when to involve the designated broker or recommend another qualified professional is an important part of competent Arizona real estate practice.